I particularly want to welcome Michael and Ivana, both very good friends, long friends of Griffith College. We're really honoured to have them here today. Very distinguished careers. And Roderick, our chairman, in fact, an equally distinguished career at the bar and on the bench. We're really proud to have you here. This is a fascinating subject, and I actually believe, I think most of us will admit that we don't know as much as we should about it. And the opportunity to inform us, the opportunity to help us make a decision today, I think is enormously valuable. Thank you for being here. And thank you for honouring us with your presence. I'm staying away from you for the reason that I have a bad dose of the flu and I do not want to pass it on. So forgive me. Okay? You're very welcome. And again, thank you for being here.
Very good. Well, thank you all very, very much for coming here. My association with Griffith goes back a long, long time, and obviously my interest in the topic which is before us this afternoon is of great interest to all of us, even if we would like to know a little bit more. And we're very, very happy to be able to have Ivana Bacik, who's a member, of course, of the Dáil Éireann, and a very well-known lawyer and indeed academic from Trinity, being Reed Professor of Law for many, many years, and so on. And Michael McDowell, again, whom I know from a long, long time ago. So clearly I have certain conflicts of interest in terms of Ivana, in fact, being my niece, and Michael being an old friend. But you can't get far away in this country without being with friends. And I welcome you all here this afternoon. And Ivana's going to address you for about 15 minutes or whatever she needs. I won't put the guillotine down just yet. And to deal with the topic. And then that'll be followed by Michael McDowell, and the rebuttal then by Ivana Bacik, and indeed a rebuttal by Michael McDowell. So I'll hand you over then to Ivana Bacik.
Well, Guramahagut, Roderick, and as Roderick has told you, this is somewhat of a family affair, although that's rather appropriate as we're going to be debating the family article in the Constitution today, Article 41. And I'm delighted to be here, and I want to thank Diarmuid for the invitation. I think it's actually really good to have the opportunity to debate in a, let's hope, what will be a relatively calm and courteous forum to debate the issues in the referendum on which we're being asked to vote on Friday. It's certainly, I think I can speak for both Michael and myself, and I say it'll be refreshing to have a little more time than the usual sound bites that we get if we're appearing on mainstream media. So it's really good to be here. And indeed, Michael and I have crossed swords, if I may say, on referendum debates in the past. I recall, Michael, when you were Attorney General and I was a barrister arguing against a referendum you were putting in 2002 to restrict abortion rights and roll back the X case. But that's ancient history as far as most of you are concerned. So look, I suppose briefly to say that my Labour colleagues and I are campaigning this week, and indeed have been campaigning, for a yes-yes vote, or a tá vote, as the badge says, in this Friday's referendum. We're calling for a yes on family and a yes on care. And I'm going to set out in the time I have the reasons why. But essentially, it's about bringing our constitution up to date on both counts, on both family and on care. It's about making a constitution that's fit for purpose in today's Ireland. And, you know, just to explain a little background first, not only was I involved in that 2002 referendum campaign, but I've been involved for many years. I'm what you might describe as a referendum veteran. Most recently, of course, very centrally involved in the 2018 repeal campaign for repeal. And indeed, when I first became active in politics, the same age as many of you, many of the students here, I was a student in Trinity in the late 80s, early 90s, campaigning for abortion rights. And I will never forget the formative experience of my political life was taking phone calls from women and girls who were in desperate situations, in crisis pregnancy, where they could not even access information on where to get abortion. Abortion at the time, of course, not legally available in Ireland, indeed a criminal offence and prohibited under the Constitution, but so too even was information. We challenged the law, we took on those who wanted to see the criminal information prohibited, and indeed we were threatened with prison for doing so. A brilliant lawyer you may have heard of, Mary Robinson, represented us in court and kept us out of prison, but it really was an experience that has shaped my, as I said, my political career. So I have campaigned for women's rights, for abortion rights, for marriage equality rights in the 2015 referendum, and prior to that looking to see divorce legalised as it finally was in 1995 in that referendum. So a lot of referendums behind me, as Michael does too. Most recently in this referendum campaign, I'm the leader of an opposition party, the Labour Party, but we are campaigning for a yes, yes on the government's wording. I've been very involved in the process leading up to this, and I'll very briefly speak about that. I was chairperson of the Oireachtas Committee on Gender Equality, and for those of you who are interested, we produced a report in December 2022 called Unfinished Democracy. I'll show you. This is it. And it sets out a blueprint for achieving gender equality. We looked at the recommendations of the previous Citizens' Assembly on gender equality, 45 recommendations for a gender equal Ireland, and we came up with an action plan, how to implement those recommendations. Care provision was a huge part of those recommendations, and we called on government to take 205 separate actions to implement the recommendations. On Thursday, we had a dull debate on our report, and Minister O'Gorman informed us that the government are in the process of implementing or have completed 190 out of 205. Real progress, and as a constructive opposition party, we'll continue to press the government to implement all those recommendations. Why is that relevant? Because the first three recommendations of the Citizens' Assembly and of our committee was for constitutional change. We wanted to change Article 41 of the Constitution, which relates to the family, and we wanted to change it to do three things. First, to create a more inclusive definition of family. The Citizens' Assembly told us, and this was 100 citizens brought together under the chairpersonship, 99 citizens and the chair, Dr. Catherine Day, who came together, representative demographically of Irish society, and who called for change to the definition of family. Because Article 41 currently recognises only the family based on marriage. And the citizens said, and our committee agreed, that is no longer appropriate in today's Ireland. It does not reflect the wonderful diversity of family life. In particular, it doesn't reflect the large numbers of single-parent families. It doesn't reflect the over 180,000 cohabiting couples, nor their children, who deserve and should be recognised, deserve to be and should be recognised as a constitutional family. So that was the first of our recommendations. Secondly, we and the citizens believed that the outdated language in also in Article 41, but in 41.2, the outdated language referring to women and mothers should be deleted. And just to recall what that is, currently the Constitution says in 41.2, by her life within the home, woman gives to the state a support without which the common good cannot be achieved. Her life within the home. Okay? And 41.2.2 says, the state shall endeavour to ensure that mothers shall not be obliged by economic necessity to engage in labour to the neglect of their duties in the home. A lot of focus on the word duties. I think the word neglect is actually particularly infantilizing of women. So we have duties, and if we work outside the home, we're somehow in neglect of those duties. I'll leave that just hanging there for a moment. So the citizens and our committee recommended that outdated text should be deleted. But the third thing we recommended was that it should be replaced with a gender-neutral provision valuing care. And it was very careful that we were very careful to say care, not carers, Because if we started just recognising carers, that would set up a hierarchy, and those who have to receive care, who need to receive care, would somehow not be right holders. So we wanted to recognise care as an entity. So to recognise both the autonomy of those receiving care and also the rights of those, the rights and autonomy of those who provide care. Recognising that all of us at some points in our lives will be carers or cared for, and often both at the same time. So those are the recommendations we made. We came up with a wording for government in December 2022. It took, unfortunately, some months for government to come back with the final version that they've now proposed and that we'll be voting on Friday. And indeed, initially in Labour, and for myself, I was somewhat disappointed that the wording in some way departed from our proposals on the committee. And our proposals had cross-party unanimous support. However, as I said, I'm a referendum veteran, and I recognise that we can only vote on the wording before us on Friday. It's taken us 87 years to get to this point, right? The Constitution is 87 years old this year. And we can't say, well, I'm voting conditionally no because I don't like this version, I want a better version. We can do that, but if we do it, we run the risk that we won't see another opportunity to amend Article 41. Certainly we in opposition would absolutely look at running another again. But the reality is, for decades we've seen promises and commitments by different governments to run referendums on 41, and they haven't done this referendum. So this is the opportunity presented to us now. This is the wording presented to us now. And after careful reflection and debate, and we put down amendments in the Dáil and Seanad for Labour, but after the debate, after we'd teased out the meeting, after we'd gone to and fro with Michael in the Seanad, our senators, and with others in the Dáil, I am confident that this does represent progress, both on family and on care. It's incremental progress for sure. It's not the best that we could have got. It's not perfect. But progress trumps perfection. Before we got divorce, we had got judicial separation into law. Before we got marriage equality, we'd voted for civil partnership. Before we got abortion rights in 2018, we had made a number of progressive steps, notably defeating Michael's 2002 referendum. So we have seen how incremental change can be very effective, and in some ways, in many ways, is often the best way to bring people with us. So certainly this is not the wording I would have proposed, but it's a lot better than what we have now. So let's go through. Why are we calling for yes, yes? And, you know, for Labour, we're saying it's a yes, yes, and. We'll be voting yes, yes on Friday, but we'll be continuing to hold government to account and pushing them to do more for families, to do more for children, to do more for carers, and to do more for those who require care, those who are recipients of care, disabled persons and their organisations, children's rights groups. We want to see a framework, a robust framework for care that must include ratification of the optional protocol, which the government are committing to doing, and which must include proper financial and practical supports, both for those who provide care and those who receive it. So we want to see a yes, yes as a starting point towards the development of a more enlightened framework on caring. And I want to use the time just to turn then to each of these in turn. On the family referendum first, the 39th amendment you'll be voting on, which I think is the white ballot paper, and then on the care referendum, which is the green ballot paper, the 40th amendment. But on both, on family and on care, we do need both words and deeds to subvert the suffragette slogan as we approach International Women's Day. We need words and deeds. The Constitution gives us the words. It also gives us an important advocacy tool to fight to ensure government carry out the deeds. So, on family, as I said, the Constitution in Article 41 currently recognises only the family based on marriage, and I've explained why that is out of date and doesn't reflect diversity of family life today, and indeed for many years hasn't reflected diversity. There have been some humorous red herrings raised in the course of the debate, some fanciful suggestions that the phrase that the government are proposing, family, whether founded on marriage or on other durable relationships, that phrase might somehow open a door for recognition of polygamy. Utter nonsense. Polygamy and bigamy are crimes in Irish law already. The family, the Constitution says, and this won't change, is the natural, primary and fundamental unit group of society, a moral institution. Can't be founded on a criminal contract. And furthermore, we know from Article 41(4), which obviously won't change, that marriage may be contracted by two persons. Without distinction as to sex, that's the 2015 marriage equality change, but it's two persons. So that is one red herring that I think we can leave aside. And indeed, there are many other red herrings. On my cycle here today, I saw posters that really shocked me from the no side. I got to say that. And I'm not suggesting for a moment that Michael or that anyone with genuine concerns about no is responsible for these posters. But this is the sort of scaremongering we're seeing from some on the no side. Here's a slogan that you might reflect on the family one. Where there's a will, there's a durable relationship. Right? Scaremongering, okay? Another one. Consider the impact on immigration. Oh, dog whistle, as we call it in politics. That's a red herring, and it's a sinister red herring. Okay, and both are saying vote no. Why are they? This is the sort of scaremongering we saw, by the way, in '95. One of the first referendum campaigns I was involved in, where we saw divorce passed by a very narrow majority. The slogan that some will be old enough to recall, that's what the no side put about as scaremongering, was "Hello divorce, bye bye daddy." Okay, so that's the sort of unfortunate messaging that has been put out, and it's scaremongering. But it's been done to confuse the debate. It's been done to frustrate progress and to leave us in the past. And I think unfortunately it has served to bring about certain doubts and concerns. So let me just try in the brief time to try and just address some of those doubts. Preemptive rebuttal, I'm calling it, Michael. First of all, why is this necessary? Well, it's going to be very important if it's passed, because it will secure for the first time recognition for those families I've described, single-parent families, grandparent-led families and others who have not constitutional recognition. And I should reveal, as Roderick and dear McDowell know, that for 30 years my own family was a cohabiting family. We've got kids who finally prevailed on us to get married in 2020, but until we did, we didn't have constitutional recognition as a family. Why does it matter? Johnny O'Mara's case shows us why. Johnny is a father of 3 from Tipperary, who I'm happy to count as a friend, but who's become very well known because he was denied a widower's pension following the desperately sad death of his partner, Michelle Beatty, the mother of their 3 children, with whom he had lived for 20 years. She got very sick very quickly and died before they could marry, and they had planned to marry. He was denied a widower's pension, and he took his case all the way to the Supreme Court, which ruled very recently, just in fact earlier this year, that his family had no constitutional protection. That's why we need to change the Constitution. Secondly, why do the problems with durable relationships? And we teased this out in the Dáil. It wasn't a phrase we used in our committee. But it is a phrase that, as Minister O'Gorman has said, gives guardrails to the courts. It's guidance for the court as to what a family can be considered. And we saw 14 eminent constitutional and family lawyers writing to the paper on Saturday, pointing out that we shouldn't be against this phrase just because it hasn't got any precedent, that it lacks legal clarity or is in some way vague. These are the accusations that have been made. They point out the Constitution is full of undefined terms, and Professor Oran Doyle in Trinity has helpfully tweeted a long list of phrases that are vague and that are in the Constitution and have been in there for 87 years. Phrases like a certain minimum education, in the Education Article 42. More recent phrases, like the phrase natural and imprescriptible rights of all children that we inserted in 2012 in the new Children's Rights Article. It's the court's job to get along with interpreting these phrases where the need arises. We shouldn't be voting no just because we think there should be more clarity. Equally, we shouldn't vote no because there's no legislation, because we don't need legislative guidance for terms like durable relationships. But if we did need it, as Miss Justice Mary Baker pointed out this morning on the radio, and she's the independent, impartial head of the Electoral Commission, we do have some guidance, in fact, from certain court judgments on what is an enduring or durable relationship, but also from the 2010 Civil Partnership and Cohabitants Act, which tells us that qualified cohabitants who get certain redress legally qualify if they've been living together in an intimate and committed relationship for at least 5 years, or 2 years if there are children. So we do have guidance. We do have guidance. But there's also the approach the courts will take in assessing that phrase in the light of other constitutional provisions, like Article 42, which says that the natural and primary educator of the child is the family. So we know durable relationships encompasses the parent-child relationship. We know it encompasses intimate and committed relationships between couples. There will undoubtedly be cases where there may have to be court decisions made, but that's the nature of a constitution, our basic law, our aspirational, foundational legal text. I'm conscious of time, Chair, and I know you were very generous, but can I take just a few more moments on the care referendum, because I think there's been certain concerns raised again about the wording of that. So we're calling for a yes vote, therefore, on the 39th Amendment, the Family Amendment. We're also calling for a yes on care. We want to see that text, that outdated, sexist text, that it should have no place in our modern constitution. We want to see that taken out. And it's not that it's just outdated now. 87 years ago, there were women's groups like the Irish Women Workers' Union protesting outside the Dáil when the text was being debated, because they saw it as so bad for women. Hannah Sheehy-Skeffington, famous suffragette, said the text is based on a fascist model in which women would be relegated to permanent inferiority. Strong words in 1937, but it's taken us 87 years and multiple reports and criticisms from international bodies to get to a point where we're being asked to delete it. Has it ever had positive impact? Because you can read it as saying, well, doesn't it give women and mothers rights to recognition for their work within the home, where they're performing a caring role in the home? Well, there have been attempts made to justify to do that, but those attempts were scuppered in a 1992 Supreme Court case, and we can go into that in more detail, but the Supreme Court unanimously, 5 judges said it doesn't give any right to financial recognition for women. So, you know, there's also been concerns raised by disabled persons, groups of persons with disabilities, suggesting that that the wording is not sufficiently broad to encompass care outside the home. And certainly our wording, and I can take you through it later if you like, our wording on the committee would have recognised care within and outside the home and family. The government wording recognises only care provided within a family by members of a family to one another by reason of the bonds that exist among them. So it's limited to family care. However, even that limited vision of care is a step forward. It's a progressive step forward, not the big step we called for, but it's nonetheless a step forward from our current text, which only recognises women and mothers as having lives and duties in the home, and which has no reference to care at all. So I'm going to leave you on this point. Incremental change can be positive. A yes on Friday for both care and family will represent progressive, positive change. And we can use it to build that to go further and build a truly equal society in line with our recommendations and those of the Citizens' Assembly. So I'm urging a yes vote on both on International Women's Day. Gur maith agaibh go leor.
Mr. McDowell.
Thank you very much. Mr. Chairman, Ivana, ladies and gentlemen, I have to compliment Ivana for asking for a polite and decent debate and then getting her retaliation in first. Particularly when she said that I had an amendment on the abortion issue which she opposed. In fact, she knows well that I was the Attorney General in a government which decided on that amendment.
That's what I said.
No, you didn't. You said it was my amendment. And you know that it was my duty to carry out the wishes of the government and to put that before the people, which I did. And it's as unfair to call it my amendment as it would be to challenge the Labour Party about their acquiescence in the outrageous attempt to abolish Seanad Éireann. There you are.
But you know I was going.
I don't remember you coming out in support of keeping the Seanad.
I did.
Well, it was very muted if you did. Now, I listened carefully to what Ivana said, and she's spoken firstly about having a wider and more inclusive definition of the family. And I should tell you that in the Dáil and in the Seanad, the government allowed 3 hours to each house to consider amendments to each bill. And the most interesting thing that Ivana said, she was initially concerned about the family amendment. She was more than initially concerned about it. She delivered a powerful speech saying that this was not what was required and that the wording was defective. And something happened afterwards that she then manoeuvred backwards to say that she was going to ask for a yes-yes vote. Now, let's be clear about what actually did happen in the Seanad, where I was. We said, if we're going to widen the definition of family, we put down an amendment saying other durable relations as prescribed by law. And the government swept that aside with a guillotine motion, which meant that after 3 hours debate, all of the amendments were swept aside, and it went, and the bill was deemed to have been passed, even though most of the amendments hadn't been properly considered at all. That's what happened. And the report stage was completely abolished. So normally you have, in a parliamentary process, you have a committee stage and a report stage, and people can reflect on the arguments they heard. They were telescoped into one, and the guillotine came down, and that was the end of it. But much more serious than that was that the normal process now in Dáil Éireann and Seanad Éireann is that there's a process of pre-legislative scrutiny. And pre-legislative scrutiny involves a committee of TDs and senators considering the text of a proposed Act of Parliament and calling in the various people from departments, from agencies, from interested bodies, from people who have skin in the game, to ask them, what are the implications of what we're being asked to vote on? And the government scrapped pre-legislative scrutiny on this occasion because they had committed themselves to having this referendum as a gimmick on International Women's Day on Friday. Sunday is Mother's Day, some of you may recall, and the present for Mother's Day proposed by the government, the gift, is that all mention of mothers will be taken out of the Constitution, and I'll come back to that if I may. Ivana has spoken about the O'Mara case, and it is a very important case, because this was a case where the government's Attorney General, first of all, opposed the matter being appealed to the Supreme Court at all. And secondly, when he got to the Supreme Court, he said that the special position of marriage was sufficient in the Constitution, was sufficient grounds to deny Mr. O'Mara his widow's pension, even though he wasn't married. And his arguments were defeated on that occasion. And because the court looked to the equality provisions of the Constitution and the children's rights provisions of the Constitution, it decided that the exclusion of Mr. O'Mara and his family from social welfare in the manner that actually happened was an invidious and arbitrary discrimination which could not be upheld by any reference to whether or not marriage was involved. So we're being asked now to put into the Constitution the phrase other durable relations. And again, the Minister O'Gorman, he came into the Dáil and said, it does not mean, the term durable does not mean the same as it does in European law. And yet we now have ministers saying it's well canvassed by the Supreme Court what the term durable means. And we even have it, I regret to say, Judge Baker, the chairman of the commission, citing a case which the minister had excluded and said is not the means of determining what durable relations actually will mean. But what will it? But when they rejected our amendment in the Seanad and rejected the idea that it would be for the Dáil and Seanad in future to determine what would be and what would not count as a family based on durable relationships, when they did that, they said it is for the courts to decide this. Now, Ivana and I well know one thing, and so does the chairman. Courts only decide cases in disputes between litigants. So what we are being asked to do is to say that marriage now means something which will later emerge from litigation between disputants in court cases, in hard cases. And this raises the fundamental question, what are the implications of extending family rights to relationships which are not based on marriage in future for other areas of law? So, to take an example, at present, and it still will be the case no matter what happens on Friday, if you're seeking a divorce under the Constitution, you can't get it unless you go to court and satisfy a judge that proper provision has been and will be made for the parties, including spouses and dependent children of the marriage. That's a safeguard put in when you dissolve a marriage, that you must satisfy the court. In other words, you must satisfy the Irish state that you can't just walk away from a marriage without consequence. Where are the similar safeguards to be in relation to people who move into informal and extended relationships one with the other? There's going to be no guarantee for them at all that one party won't simply exit the relationship and say it's over. But we have tried to deal with that kind of situation by our cohabitance law, which is set out in the 2010 Act. And the cohabitance law says that in order to get any remedies when a cohabitation breaks down, you have to have been cohabiting for 5 years in an intimate and committed relationship between two adults, or in the case where they have had a child between them, 2 years. And even then, the Cohabitation Act provides that nothing that the court can do in terms of sorting out maintenance or readjusting property between such a couple, even then, they say nothing that a court can do can affect the right of any person who was or is a spouse of either party to the cohabitation. That's the law at the moment. How could that survive a situation? How could that survive a situation when you bring onto the stage of the Supreme Court the equality rights, the children rights, and now equality of family status, and say, I demand equal treatment? The fact that I'm not married surely cannot mean that the original spouse of one of the parties to the relationship trumps everything in that her rights or his rights remain inviolable. And the reason I make that point to you is this. Successive ministers have said this will change nothing. Nothing will change. But the O'Mara case to which Ivana made reference makes it very, very clear that from day one, from next Monday, any case that comes before the Supreme Court, the court has to look at what the Constitution now says, and it has to do its level best to ensure that all the provisions of the Constitution are respected, and there is nothing in it which would suggest that, for instance, in the case I've mentioned, that the rights of cohabitants under Section 202 of that Act to opt out by legal agreement from the obligations of marriage will be allowed to continue in future. Now, I give you the following example. If there's nothing in, by the way, in the language of this amendment which actually talks about single parents, nothing at all. It's because Judge Marie Baker today said that durable relationships will be analogous to marriage. I don't know how you could say that single parents actually do fit into it as of right, but government ministers keep saying it, although they haven't provided it. Nobody, and everybody who's studied law for any considerable time and the Constitution and the court's decisions believes that single mothers have no rights. Of course they have rights. And the courts are jealous to protect their rights. And the courts are very keen to say that just because you're not married doesn't mean that your relationship with your child is inferior to anybody else's relationship with their children. And nobody can point, and we'll have refutation later, I ask and challenge Ivana now to point out one instance in which passing this referendum will give, if it does apply to single mothers, a right that they didn't have before. There simply isn't. There isn't such a thing. Now, let me give you another example. Single mother and her child. A man comes into their life and they have a second child. She was, you're supposed to believe now, going to be in a family based on a single durable relationship with her first child. Now you have a situation where another family, or is it the same family mutated, has come into existence based on the man and the woman and the fact that she has one child and they've shared another child. And he moves out and moves into a second relationship for him. There's no protection for her of going to court and getting the court to make proper provision for her. None at all. She obviously would be entitled to maintenance, but she won't be on the same level as somebody else. But he will now be in a second marriage, family based on a durable relationship for him. And what happens to her first relationship, which gave rise to the single mother family status, or the second one which he has walked out on? Nobody's explaining all of this. But the ministers who have spoken about this, Minister Thomas Byrne and Minister O'Gorman, have said that those second and subsequent relationships will be families recognised by the Constitution. Now, go back then to the definition of family, which is still going to remain, that it's a moral institution possessing inalienable and imprescriptible rights. It's the fundamental unit group of society. It is an institution with its own constitution and authority as the necessary basis of social order. And ask ourselves whether the triple family situation that I have just adumbrated to you is the necessary basis of social order. Is there any social order? Or is this something which is just simply being ignored because it's too inconvenient for the legislature to deal with, and we'll find out from the courts what they think. Now, what I do, Ivana and myself both supported vigorously the repeal of the Eighth Amendment. We both supported vigorously the marriage equality referendum. So I'm not going to take being boxed into a corner as some kind of legal conservative on this. I'm not approaching it from some right-wing Catholic perspective. I don't have such a perspective, I can tell you that. But my good friend Adrian Hardiman, who later became a Supreme Court judge, was a barrister when the Eighth Amendment was originally contemplated. And he said, on questions and answers, he said, there will be travel injunctions if this is brought in. And he was decried as scaremongering. Scaremongering was the phrase that was used. 11 years later, the Attorney General, Harry Whelan, sent in counsel to the court and got a travel injunction from Judge Costello. It was appealed to the Supreme Court, and he tried to uphold the travel injunction there and failed only because the Supreme Court were concerned with the fact that the child, an innocent 14-year-old girl who was pregnant as a result of rape, was suicidal. And they said that trumped the travel injunction. And what happened after that, let's not forget this, is that we had 3 referendums run together on the same day, very much like what's happening now. 2 of them were accepted and 1 rejected, to try and undo the Supreme Court's decision because it was so unacceptable. One was to do with information, which had Ivana teetering on the edge of Mount Joy. And the other was to do with the right to travel. And even after all of that, the 2002 amendment tried to solidify the suicide ground, and it was rejected narrowly. And then we all got together and said, this was a disastrous mistake in the first place. The Eighth Amendment is something we just don't want to leave in existence anymore, and we removed it. So people who say to you, I mean, everybody who was in charge of the Eighth Amendment campaign at the beginning, who was poo-pooing Adrian Hardiman, who, as I said, later became one of our best Supreme Court judges, poo-pooing his warnings about what would happen. Everybody said, there's no problem here. We're just trying to be pro-life. And the notion now is we're just trying to extend family rights to people who may not have them. But who is at the moment? There are people cohabiting, by the way, and one of the interesting points about the O'Mara case is that the Supreme Court, in its majority judgment, said nobody is obliged to get married. In fact, everybody is free to cohabit without getting married. And they gave us the reasons that some people don't want the obligations and some people don't want the state interfering in their private life in the sense that marriage represents as a legal status, a public law status. The situation that we find ourselves now in is that we're being asked in the marriage referendum, the family referendum as it's called, but it's basically to do with making family, breaking the link between family and marriage, that we are being invited to put into the Constitution something grossly uncertain, something grossly ill-defined, something which will have implications along the same lines as O'Mara for tax, for welfare law, for pensions, for deportations of non-nationals, for property rights, and for succession law. And if you doubt me about the succession law, I'll ask Ivana to deal with the following. Two families next door to each other. One of them is married and the other is not married. One of them, the male partner runs a garage and he dies suddenly. And he's in the unmarried house. His wife at the moment, or his partner at the moment, would face major inheritance tax issues if in relation to the business and quite possibly in relation to the family home if she wasn't entitled to the exemption which is provided for in respect of residences. It could be crippling on her family. And if she came to the Supreme Court and said, my durable relationship as a family, we as a family face serious consequences as a result of the tax law as it is. And if we had marriage 19 years ago, everything could have gone from the man to the wife without tax of any kind and would have been tax-free. We want justice. You tell me that the Attorney General would, after O'Mara, succeed in saying, marriage allows the special status of marriage allows for that distinction between the two families. It won't happen. And the reason that I mentioned that, maybe it wouldn't be a bad idea if it did happen, by the way, if the Supreme Court did find for the people next door in that way. But the reason I mention it is that day in, day out during this referendum campaign, I have said there will be taxation consequences. And I saw Simon Harris shaking his head the other day on the Week in Politics as I said it. I know as a lawyer it will have those consequences. They may be good consequences or bad consequences, but to say this changes nothing is simply wrong. Now, I just want to mention two things. So, Ivana mentioned the L&L case and said that it didn't, that the Article 41.2 didn't deal with financial provisions as between husband and wife. Not so. It does. It stated very, very clearly that the exact words that they're proposing to delete now guarantee when couples are splitting up that the alimony from one to the other will not be fixed at a rate that forces the woman out to work. And that was also confirmed post-divorce in the CT decision. And in the famous Murphy, or it wasn't this Murphy, tax case, where the Supreme Court invalidated an income tax act which was discriminatory against couples, one of whom worked in the home. The exact words that we are being asked to take out were relied on by the Supreme Court. And there is a case fixed for the 11th of April where those words are being relied on by a woman who has an autistic, epileptic child, very seriously disabled. And she appealed to the Supreme Court to have her case adjudicated on by reference to the article which is now proposed to be deleted. And the Supreme Court said it was a matter of systemic importance for persons in her position. And this referendum, which seeks to remove the words on which she's going to rely, was fixed for the 8th of March, approximately 30 days prior to her hearing, to make her case moot. Now look, when it comes to the care amendment, I'll deal with it later, I don't want to take any more time, but when it comes to the care amendment, I do want to say this, that there is nothing sexist and nothing in any sense misogynistic and nothing anti-woman in providing that the state has an obligation to ensure that women are not forced by economic necessity to work outside the home when their choice is to be a parent within the home. Thank you.
No.
Well, where to begin with my rebuttal? Yeah. And given that Senator McDowell took such a lengthy time to make his case, I think I'll have a little more time. Look, even for Michael, and we are friends in many other respects, and indeed soldiered side by side on the Judicial Appointments Bill in the Shannon, lest you think they were always on opposite sides. But even for Michael, that was some extraordinary feat of twisting language, if I may say. It seems as if Michael wants to have his cake and eat it. He suggests to us that the 39th Amendment, if passed, won't make any positive change for single parents. But then he provides lots of, what, if I may say, wild speculation about the impacts it's likely to have in loads of other spheres. Tax, succession, a little bit like hello 39th, bye-bye daddy at one point, I thought, when I listened to him. Let me just say this on that point, that the 14 constitutional and family lawyers' letter on Saturday in the Irish Times, family lawyers like Conor O'Mahony, constitutional lawyers like Aileen Kavanagh and David Kenny, who didn't advocate one side or the other, by the way, they're simply saying that the wilder speculation, they say, assumes that the family amendment would grant durable relationships a status similar to marriage. This is not the case. And I took down very carefully one phrase Michael used, which is actually just plain wrong. He said it would be breaking the link between family and marriage to vote for the 39th. It certainly would not. If the amendment passes, as the lawyers say, Article 41 will still oblige the state to guard with special care the institution of marriage and protect it against attack. So the link is still there, and the special status for marriage is still there. Other durable relationships don't get that status. So the amendment would not equate durable relationship with marriage, civil partnership, or even with qualified cohabitation, although those provisions in the 2010 Act do give us some guidance, I think, or would give the court some guidance. However, the 14 lawyers say it would not be possible for an individual to claim tax, succession, or social welfare entitlements simply on the basis that they are in a durable relationship. They go on to say that the extended definition would have few practical effects, but its principal relevance is the statement it makes about the forms of family that warrant constitutional recognition. It's about an aspirational statement. That's a large part of it, for sure. But it's a progressive statement. And it's a statement that means a lot to families, yes, single-parent families, yes, cohabiting families. And again, an extraordinary twist of language for Michael to somehow equate this amendment with the 8th Amendment, with its deeply regressive and sexist and infantilising of women. I was too young, by the way, to vote or campaign in 83, but by God, I grew up under its shadow. And I did not want my teenage daughters growing up under its shadow. I'm so happy that we've repealed tackled it, but to suggest that in some way this amendment is in some way analogous. And by the way, it was Mary Robinson who first predicted that it would have that effect in '83, as well as alongside Adrian Hardiman. So, you know, this is very, very different. This is a progressive step forward, and it will make huge changes. Michael asked a couple of specific questions. He asked about, he engaged in a little bit of scaremongering about the taking out of mothers. Look, there's still reference to women and men in Article 45 of the Constitution. Whether this referendum is passed or not, that's there. The only reference to mothers currently in 41.2 is that deeply negative one. It can only be read in a sexist sense, particularly because there is no reference to fathers. And that's deeply unfair and discriminatory against those fathers who, for most fathers now, who take such an active role in parenting of children. Michael asks, how can we be sure it will apply, the change would apply to parent-child relationships as well as cohabiting couples? Well, because we read it in conjunction with Article 42, as I've said, which says that the natural and primary educator of the child is the family. And we have to read the constitutional text together. So we have to be clear that it will apply to the parent-child relationship, what in the debates we sometimes call the vertical relationship, not just the horizontal relationship between two people in an intimate and committed relationship as a couple. So I think it's fear-mongering to suggest that it won't apply to single-parent families. I think we can be very confident that it will. It's also fear-mongering to suggest that we're breaking the link between family and marriage, as I've said, because marriage retains a special position. The L&L case, Michael referred to that. Of course, as Michael well knows, in the L&L case, the big point was that the plaintiff, represented then by Catherine McGuinness, had argued that her work within the home should give her an entitlement to a stake in the family home, and that's what the Supreme Court unanimously rejected. A couple more points. You know, there was a referendum in 2019 that many of us perhaps don't recall. That was the referendum which changed the constitutional text on divorce in 41, took out the requirement for couples to have been living apart for 4 out of the previous 5 years before they could get a divorce. Now the text says there must be no reasonable prospect of reconciliation. That amendment passed by 82% in May 2019. People recognised the need to change the Constitution to reflect modern life, to ensure that people wouldn't be forced to spend this sort of fake period living together or living apart in order to get a divorce. And I think we must recognise that impetus and momentum to bring our Constitution up to date. I want to say, just to nail Michael's point about the process, we were always clear in Labour that we wanted to see the wording the Constitution, the Oireachtas Committee had come up with. So we were disappointed, and I was very clear about that. I said in public interviews extensively in December, January, we were considering what way to vote. But ultimately, we recognised that this is a binary choice on Friday. We can't be a conditional yes or a conditional no. We have to come down on one side or the other depending on the wording that is presented to us, not some sort of hypothetical better wording, not even on the great wording we had produced in our committee. And ultimately, yes, yes is a progressive vote. It's a vote for more inclusivity on family and more inclusivity and less sexism on care. I'm a mother. I don't want to wake up on Mother's Day on Sunday and realise that we have voted to retain a deeply sexist and outdated text that somehow suggests mothers who work outside the home are neglecting our duties in the home. How can that not be sexist? I want to wake up in a society that has voted yes, yes on inclusivity and on care. Inclusivity for families and inclusivity for all who give and receive care. Gurmagwa.
Well, I asked Ivana and I challenged her to identify one individual aspect in which...
You asked me many things.
No, well, I asked you that, and I saw you take a note of it, and I hear nothing in reply.
Which question?
That was to identify one respect in which a single mother will be deprived of, will get enhanced rights by virtue of this amendment. You didn't answer it. Yet you haven't. You've said you've put it all on the level of aspirational recognition without consequence. I don't accept that. And the second thing is that what you said about this deeply sexist, disparaging language in Article 41.2, it's been relied on by the courts to guarantee rights for women, as I said. In the L&L case, it was relied on. In the Murphy tax case, it was relied on. And in the LT and CT case, it was relied on to defend women against suggestions that they could be forced out to work against their wishes, which were to to conduct parenting in the home when there's family breakdown. The second thing I want to say is that everything that has been said ignores what Susan Denham, the former Chief Justice, said about Article 41.2. She said, "This special recognition is of the 21st century and belongs to the whole of society. It's not to be construed as representing a norm of a society long since changed utterly. As important now as ever is the recognition given. It is a recognition for all families of whatever religion or none. Thus, in Ireland, in relation to the family and the home, women have a constitutionally recognised role which is acknowledged for as being for the common good. This gives to women an acknowledged status in recognition not merely the physical aspect of homemaking and family building, but of the emotional, social, physical, intellectual and spiritual work of women and mothers. The undefined and valuable role of the father was presumed and remained unenumerated by the drafters of the Constitution. Article 41 does not assign women to a domestic role. Article 41 recognises the significant role played by wives and mothers in the home. This recognition and acknowledgement does not exclude women and mothers from other roles and activities. It is a recognition of the work performed by women in the home. The work is recognised because it has immense benefits for society. This recognition must be construed harmoniously with other articles of the Constitution when a combination of articles falls to be analysed. That is an enlightened, liberal Chief Justice speaking when she was an ordinary member of the Supreme Court about the real meaning of the provisions which are now proposed to be taken out of the Constitution. They are protective of women. And I want to just finally say that we haven't said much about the Care Amendment. But the Care Amendment is a toothless amendment, utterly and completely toothless. It suggests, and let's be clear about this, it suggests that care in future, that the state's obligation is to assist family members because of their bonds of loyalty to each other, to confer care on each other. It's an abdication of the state's role in relation to providing care to all disabled citizens equally and to those who care for them equally. It's an abdication of that. And Tom Clonan, who's in the Senate with me, has been passionate on this subject. And I just want to make the point that care for somebody who's disabled and who wants to live an independent life in the community should not be boxed into what his family or her family is willing to do for them. And that's what the language, you were talking about sexist language, that's what this does, because the vast majority of care is provided by women in the home. And the reality is that this is saying, that's your problem, it's not the state's problem. And I just want to say one last thing, because reference was made to Professor O'Mahony as being one of the signatories of this letter. What did he say about the care referendum? He said, in practical terms, the use of the word strive and the omission of the requirement to take, quote, reasonable measures, unquote, means that no remedy other than political campaigning will be available if future governments ignore the aspirations of Article 42b. There is no new right given to disabled people, no new right given to carers, nothing except flannel to put up on posts, yes care, yes family. It's illusory and it's deceptive. Thank you.
Thank both of you, Ivana and Michael McDowell, for a very, very deep appraisal of what is before us this week. So that at this stage, we have very little time left because we thought we would finish before 2 o'clock. It's just after that now. But if there are some questions, perhaps we could we can maybe take that question there. Just
I'll take a few questions
yeah.
and come back and we'll just
yeah. Okay. No.
So I am a housewife. I'm also disabled, and I also feel that these amendments that you are trying to put in and throwing disabled people under the bus is very insulting to people who live with disabilities. I think I've seen Roderick O'Gorman, for example, saying if a yes vote comes in, there'll be more money being put in towards people with disabilities. I go, you could do that now. Why do you need us to vote yes? And as for this, like my mother is also a self-employed woman, runs a hardware store, which is breaking all, if you excuse the expression, gender boundaries. And this article has never held her back, or my grandmother, or women before her. So I just think we should vote no anyway.
Ivana, would you like to?
Well, do you want, maybe to speed things up, we take a few contributions.
Oh, right. Very good. Yes, can I just take you there in the front row?
I came here today with a completely open mind. And there's only one thing I would like to ask Mr. McDowell, and that is in reference to the taxation, the inheritance tax. Surely the answer to that is change the law. Now, the other point I would like to make very quickly is that I think debating this yes or no is like putting deck chairs on the Titanic. When you consider that this Constitution will not be changed in my lifetime, but could be changed in the next 5, 10 or 15 years. And we should be spending that time educating the people about the qualities that are in it and the things that will have to go. For instance, we are the only country in the world that I know has an autochthonous written constitution. And that should be pointed out to the people and what it means that no decision of the people in referenda can be overturned by the government. Whereas in Canada, they can vote out something and it can be overturned by 2/3 majority of the government. The other thing is that we have the best electoral system in the world. America has a lousy electoral system and England has none at all. They're just a waste of time. And therefore, that should be pointed out to the people. And the other thing that should be pointed out, that all references in our Constitution, in the preamble, reference to the Trinity and to God, were put there by De Valera for no other reason but he was hoping to get the imprimatur of the Pope at the time. And he sent his envoy to Vatican. And the Pope refused the imprimatur but said he would not openly oppose it. And the reason why he refused his imprimatur was that in the Constitution it mentioned the Church of Ireland and the Jewish community, how times have not changed. Thanks very much.
Any other questions? Yep.
Question for the individual on the left with the short blonde hair. I noticed that you're wearing a badge with Ta.
I have a name.
Oh, sorry, I don't know your name, sorry.
It's all over the
Ivana.
poster.
Sorry, all right, Ivana. Oh, how are you doing? Yeah. I've just come in from Meath today. Now, I'm a musician. I'm creative in the arts. I got out of bed on Sunday morning to come down to this. That's how strongly I feel about this. This is normally a snore fest for someone like me, this type of thing, right? Now, you're wearing a badge with Ta, which signals that you're somehow endorsing the notion of Irishness. Now, if you know anything about Ireland, Ireland is based upon the notion of the sacred feminine. Good for you, but Ireland is based upon the notion of the sacred feminine, which is Roisin Dove, Grania Whale, Kathleen, the daughter of Houlihan. What you and your ideology are obsessed with deconstructing that and bringing in some sort of a neo-Marxist. It's what it is deconstructing the notion of the sacred feminine.
We've got your point.
Here. Thank you very much.
Anybody else? Okay, last one then.
Yeah, I have a question. I'm from County Meath. I became a mother 9 years ago after a very successful, lucrative career which moved me to this country 21 years ago. Unapologetically, I am a stay-at-home mother, and I feel that the propaganda being shouted about by the government, media, NGOs, much of it is misinformation, which has been called out. Some of our senior ministers have been propagating misinformation, but they're trying to make women feel that it is offensive, misogynistic, and outdated to be at home caring for children. I have a 5- and an 8-year-old, which I was blessed to have in my 40s, and I unapologetically choose to stay at home, and I completely oppose Article 41 being removed from our Constitution and downgrading my position as a mother, because it's one of the most important jobs in the world.
Thank you very much.
The question I have is, what benefits of Article 41, the maternity protection, child benefits, solo parent benefit, those are given to us under Article 41. If that's deleted, what will happen to those benefits?
Oh, very good.
There's 64 pages of minutes being hidden about this referendum by O'Gorman.
Good, thank you very much. The last question, I think, was second row. Just, yeah, your hand up.
With your camera.
Thank you.
Thank you.
And if you could be brief, please.
Yeah, so to make it quick, I have two questions for the Yes campaigners. One, much like the woman has just spoken, if there is a time that any workers are not going to be, women or anyone who just decides to work at home has to go out and work, how are their rights going to be protected to stay at home with their families? And my second question is regarding the care amendment. Oh God, sorry. Yeah.
Ivana will deal with the thing first, and then Michael McDowell.
So thank you for the comments. I think it's first to say it's a long time since I've been accused of being a neo-Marxist, but thank you. I'll take it as a compliment. Joking. First of all, and thank you for your contribution. And just to say, our wording from the Oireachtas Committee was a more inclusive wording on care, and I'm talking specifically about the care provision. We wanted to see recognition of care within and outside the home and family. I still think that would have been better, and it would certainly have been more inclusive, and it certainly would have reflected what the disabled persons organisations that came before us and that gave us evidence and gave us the benefit of their lived experience. That's what they wanted. So I'm really, really appreciative of your comment, because I think that's really important. And I'm also conscious that a huge number of disabled people are themselves carers. And of course, and there are many, many women with disabilities, because equality is intersectional, right? It's not women and disabled are being people. There's some sort of tendency to pit two groups apart, against each other. Far from the case. We need to have a much more inclusive understanding of care altogether in all its forms. And just because the vast majority of unpaid carers are women does not mean we need to enshrine that as a fact in our constitution. We need to tackle that and enable and support more men to perform caring roles, as so many are doing. Men with disabilities, men without disabilities. Some really interesting points to make, that 45% of family carers in Ireland are themselves disabled persons. So this is much more intertwined, and as I said, I would have preferred a much more inclusive wording on the 40th Amendment. But we do have this binary choice. Do we want to see a deletion of the text that confines women and mothers to one role, doesn't recognise fathers at all, and that doesn't mention care at all? Because currently there's no recognition of care. There's only women's lives and mothers' duties. And that reads to me as discriminatory against men, and also as confining of women. And absolutely, to those women who spoke about, and men who spoke about choice, it's all about choice. Of course, women who want to stay in the home, or men who want to stay in the home, should be supported and encouraged to do so. And for Labour, we stand for a social democratic model of care, a care system where people are supported in providing care within the home if that's their wish, or in accessing care outside the home if they wish. So, we're looking for a more inclusive conception of care. This is a step in the right direction for me. It's not by any means perfect, far from it, but it's better than what we have, and that's why I'm voting yes, yes.
Thank you very much.
Well, just very briefly, I did ask twice for any indication as to what difference this would make to the life of a single mother. And I haven't heard an answer, because it would make no difference whatsoever. The second point is that there is a groundswell across the country of people who say, sorry, there's nothing sexist, misogynistic, or in any way demeaning to acknowledge the truth that motherhood and fatherhood are slightly different things, and that all men, even the most liberal and enlightened men in general, know that mothers have a role in child rearing which it is very, very difficult for men to replicate, although some are obliged to do so. And the last point is this. There is no truth in the suggestion that the Constitution says or implies that woman's place is in the home. It in fact says the exact opposite. It says that men and women equally have the right to earn their livelihood. That's in Article 45 of the Constitution. All citizens, men and women equally, have the right to go out and earn their livelihoods. But what it was there to do was to preserve one thing. And it was true in the 1930s of De Valera, and it's true today, that many, many parents are forced by high rentals, high cost of living, high expenses on their houses, mortgages and the like, to go out and to work when they really would choose not to do so. And many of them work part-time in order to span the gap. And they are entitled to have recognition of what they do, given just as much value as people who actually go out and earn a wage packet. Both are equally important. So on Mother's Day, on Sunday, do we wake up and find out that on Saturday, mothers were taken out of the Constitution? I don't think so. Thank you.
I want to, on your behalf, I want to thank both our speakers who have spoken from the heart, but also with great academic understanding of what we're being asked to do in this referendum. Thank you all very, very much for coming, and particularly those of you who've had questions. Thank you very much. If I could just give the chair to to Professor
Just could I
Hegarty.
say something very quickly before we go? I have known both Ivana and Michael for many, many years. I was interested, Ivana, to have you accused of deconstructing the image of Granuaile. I would have thought that you have actually very much lived that image in terms of your passionate and active promotion of women in Irish society. And the other thing, as I said, I've known, it just strikes me that, however, that you also epitomise, as does Michael, the clear view that the word is mightier than the sword. Something, in fact, we should all bear in mind in the light of what is happening in Ukraine and Israel at present. The word must be recognised as mightier than the sword. And this man, in actual fact, as Senator, as TD, as Minister of Justice, and indeed as Attorney General, who has been very much dealt in the business of words and argued so eloquently, as did both of you. Thank you for being here. Thank you for what you've contributed. Really, really appreciate it. We at least now go out, I suppose, a little bit better informed when we put our X on the ballot papers. Thank you for that.